Hi, I'm Steve Carlson. I am challenging Al Franken in a contest because of his conduct in violations of First Amendment rights and also other irregularities in the conduct of that election. I'm challenging his election. I'm also challenging the action of the state to downgrade the Independence Party from a major party because this election was not valid. It was a farce. It was just a stage production by a showbiz personality of Al Franken. When he gets a little power, he'll put out the First Amendment. So again, it's based on irregularities and it's based on serious material and deliberate violations of Minnesota election laws, and those election laws do include the First Amendment and the other parts of the Constitution, especially in Article 1, which explain how members of Congress are supposed to be selected. And as I pointed out in the first part of this series of videos on this election contest and the problems here with what I call the Wild West of election rules here in Minnesota. Once the election starts up, whatever's down on paper, they'll throw that out the window and they'll do everything they can just to cling to a little bit of power, this duopoly of the Democrats and the Republican Party here in Minnesota, and total disrespect for the rules, total disrespect for the Constitution, and especially for the voters. And so that's what's at the basis of this action. Now, to set out the irregularities, and the second one, the violations of election laws, I specified 4 particular grounds, and each one of these weakens the voting rights of the voters of Minnesota and the voters of the United States, because these things are done all across the United States. Now, in this year, I had to fight with the 2 big parties who early on announced by little rumor gossiping in the papers that probably they were just going to try to debate themselves for the whole season. They weren't going to include the Independence Party. The Independence Party in Minnesota is a major party. Now that status is in question because of the results of this, what they call an election that happened on November 4th. But it was not an election because it did not follow the rules prescribed by the Minnesota legislature to select a U.S. senator. And Al did everything he could to just kind of stay outside of the debate. And really, there was nothing of substance said in the little show debates that took place between Mike McFadden and Al Franken. We learned what we already knew, that Al was up there basically to vote for whatever Barack Obama wanted him to vote for, and we can all see how badly that is going for the country. And so the loss of this genuine election and genuine dialogue, where the positions, arguments, and qualifications of all 3 major party nominees could be put before the voters, the loss of this was a major blow to democracy in Minnesota. And we need to restore that, and because that is something that the Tea Party and the Independence Party, and I think all independent voters, really want to see: the restoration and the maintenance, the protection and securing of the rights, which are the basic foundation of this nation's society and form of government. And we're quickly seeing that erode, seeing all kinds of conflict, tearing the country apart. This is the demagogic strategy of the Democrats, of the demagogic party, the Democrats who basically just demagogue away our Constitution. We are warned by this, by the framers and the Federalist Papers. I suggest everybody read that. Right now I'm just going to kind of set out the arguments. There's some really powerful arguments in here for why the rights of the voters, and even the rights of voters to associate as parties, need to be protected. And the Supreme Court has spoken to this very strongly. However, it seems that once the elections get going, the 2 parties, they only heard the parts that help the Democrats, or they only heard the parts that help the Republicans. What you're going to see is that this strong action, beginning with the Anderson case in 1980 to protect the rights of parties, was because of independent voters. There wasn't at that point even an independence party here, but there was an independent campaign, and John Anderson got 6%. And everybody makes fun of a smaller party, even though a major party that gets about 6%. But they get on the ballot, they enrich the debate, enrich the dialogue, and they let more people and more ideas be involved. Unfortunately, our media cannot handle more than one idea. They can handle the idea of the party in power, and then they can handle, well, maybe there are some other ideas. And so if it's about the Democrats, well, let's go see what the Republicans have to say. They totally skip over the fact that most of us are not Republicans and we're not Democrats. And so it's our ideas that count as the voters, not what the Republicans say. So if you don't like what Obama says, that doesn't mean you go and let the Republicans talk and then just go on with it. No, all of us have to be involved. And this is the richness of the debates and of the elections, which the Supreme Court has made very clear is the bedrock of our democracy and our democratic elections. And even our Minnesota legislature, outside of the elections, has established some fixed procedures for elections. And these are just willfully violated. And unfortunately, in ground one, the violation comes from the Minnesota judges themselves. Now, because the laws need to be enforced, the legislature, in its wisdom, set up a role for the courts. And especially now, this contest had to come through a district court, but then because it's a statewide contest involving Al Franken and the question of the Independence Party, it goes straight back to the Minnesota Supreme Court. However, all they're allowed to do, because of the United States Constitution, puts all that power right in the hands of the Senate itself. And no court, no tribunal, not even the U.S. Supreme Court, can set aside the election and void the election of Al Franken. However, the Senate can. And so the role of the courts is to collect that information, to certify it, and pass it on. Now, in their response, Mark Ritchie, I haven't seen one from Al Franken yet, but in their response, Mark Ritchie attempts to suggest again, and this has happened before, to the courts that they ignore their role, that they go ahead and violate the Constitution again, and that they quash these items from going to the United States Senate, even though it's in our state law. And even though our state law prescribing that limited process for the courts is necessary to make real, secure the procedures protected by the U.S. Senate in the United States Constitution when it was founded. But they still play with it because they have these high positions. However, here's ground one again. They have disallowed, as I set forth here, the following required procedures: elections contests. They blocked it in 2012, so two of these issues having to do with quotas, race quotas, gender loading, and socially engineering the endorsement process to put people on the ballot. Now, it's true that you can win the DFL endorsement here, and you can still run against them in the primary, the endorsed candidate, and win. This year, I ran against the endorsed candidate of the IP, the Independence Party, and won. Mark Dayton was able to do it, but he's a millionaire who has been married to a Rockefeller. And so for most of us, it's very, very important that the endorsement process be constitutional. So that's one of the big arguments they have not allowed to be heard in the 2012 contest. Now it is going to be heard, unless they try, again, illegally to stop it. The second thing that was stopped in 2012 was the use of public information, email addresses, voter email addresses, which are collected by the state, which have not been classified, nor could they be classified as private information. And as I say, Mark Ritchie has taken these voter email addresses home and used them to raise funds for his own campaign. Now, it's hard to get all of the details because he kind of hid that And the only way that it was discovered was two Republicans attended these groups where he was collecting, supposedly civic education, and he was basically just building up his campaign using the Secretary of State's office. And Mark Ritchie now will be out of office. He did not run again this year. And so that's, I'll give you more detail of that. But the first ground is that the elections contests were not allowed in 2012, and elections petitions are also not allowed. That's under another rule. It's 204B.44 of the Minnesota statutes. The contest is Chapter 209 of the Minnesota Code. So they then have limited this. They pretend the judges just decided, hey, we don't want to deal with our role. We don't want to carry out our responsibility. But if there's some problems about the ballots or something, you can talk to us. But anything else they do, it's the Wild West. But that is not what's fixed in this Midwestern state code by the state legislature. The election laws require a rule for the judiciary. And they're all elected themselves, by the way. And otherwise, they're appointed by the governors, even though they're not supposed to be. But they work out a deal where they pretend that they got to go right now and they can't wait for the next election, because in our Constitution, we're supposed to be electing all these judges. But the governors play footsie with these judges, and all of a sudden, at election time, these judges present themselves as some glorious font of knowledge and wisdom and justice. Well, they're deliberately abrogating and abdicating from their responsibility to make sure that we have free and fair elections. This is not a priority for many of these judges, and I've noticed that justice is also not a priority for the justice system, and I think that's something that people are widely recognizing, and it's very important that we protect the justice system and make it work. I'm talking about the roles. So the ground one includes the disallowance of these state laws and also of congressional action regarding the qualifications of members. So here it would be Al Franken. So if you look at U.S. Constitution Article 1, Sections 1, 2, 3, 4, and 5, they all talk about how the Congress is to be put together and how we're supposed to make sure that they're selected, qualified by free and fair elections. So this ground of blocking of all elections contests and election petitions, which are procedures established and fixed by the elections laws of the Minnesota legislature regarding irregularities and violations brought here as these violations affected the 2014 U.S. Senate elections. That is what ground one is, that they just stayed out of the way. Things were brought to them during the elections. They were supposed to remedy it. They wouldn't do it. And they let Al and Mike get away with the Wild West of Senate elections. Now, ground two, then, is the disallowance, as I was mentioning, of access to DFL voters, so that I could campaign for endorsement in 2014. And that was on the basis of gender, race, and sexual practices, homosexuality, which violates the First Amendment, U.S. Constitution, Articles 1 and 4 of the U.S. Constitution, and also the 15th and 19th Amendments, because you can't deny or abridge of voters' rights, to participate in a precinct caucus because of my gender or because of my race. Or anybody else, because when you segregate people by race and gender, which is what the Democrats do, what you're doing is you're weakening everybody. You're creating disunity, and you're just gutting the power of the people to assemble and choose their representatives in Congress. So this disallowance was affected by the DFL and by the Minnesota legislature Secretary of State in enforcing the state's requirement both of those have created a requirement that anybody who votes and participates in the precinct caucuses and conventions of the Minnesota DFL have to agree with this system of gender, race, and sexual practices, special definition of delegate seats. So you'll be thrown off if you don't fit into one of these little boxes. And so everybody who votes and participates need to go along with this. And this is in itself unconstitutional as applied to exclude people from voting and participation, and all of those who can't agree with a system of quotas and selection of delegates and officers are excluded from the DFL party. And many voters don't even know that. So that's the second ground on which I'm challenging the election of Al Franken, because, of course, this is his party. He's the big shot there, and he benefits by this just crazy configuration of the delegates who are allowed to endorse for the office of U.S. Senate. Ground 3, the blocking of access to voters through televised or radio broadcast debates with the incumbent Al Franken and Republican Mike McFadden, in violation of the First Amendment, U.S. Constitution, freedoms of political expression and freedom of association, and of U.S. Constitution, Article 1, Sections 1 and 4, U.S. Constitution, all made applicable to Minnesota's actions by the 5th and 14th Amendments, U.S. Constitution, and the equal time requirement in the Communications Act of 1935, Section 315A. That's also violated by this. Now, here's just a few facts about the debate issue. One of the rights of a Minnesota major party is to have its nominees be placed on the general election ballot, chosen at a primary election. The election held August 12th, 2014, which I prevailed in. And therefore, I represent the interests of the Independence Party and the independent voters who voted for me. Now, IP employees like Mark Jenkins, he went to the media because he and those media did not like my emphasis on religious liberties and my disgust at the so-called homosexual marriage, and claimed and widely published at the time of the first polls of the Senate race that IP employees supposedly had the power to nullify my primary win and disown me, as if they ever owned me or had any authority over me at all if I won the primary, which I did. And so therefore, these polls that they talk about, those have to be cast aside. People were, when they were called, they were watching this on the newspaper and on television, that here are these people, what's left of the IP party, and what they're doing is disowning their candidate because he won't go along with a litmus test on homosexuality and on drugs, the utter deregulation of marijuana so that they could tax it and raise revenue for the state. I'm against that. And so because of that, they attacked me in the paper, and at that time they took a poll. And so I believe that poll has to be thrown out. And I had no chance to counter these ridiculous statements being made by Jenkins and others. Tom Check was making allegations. He works for NPR. He's supposed to be media, but here he was out there telling lies and attacking my candidacy. So at that time, they took the first poll. Had I been allowed in these debates, all of that could have been cleared up. That was another reason why there needed to be a debate. But while some in the IP may not have considered primaries to select nominees in advantage after I beat their endorsed candidate in the primary, it is a precious privilege because it provides the IP and its nominees access to the ballot. I was at the top of the general election ballot, which is one reason why they were all coming after me. And in fact, the top of the ballot, if the party had less votes, because we got the top of the ballot because we had less votes than the Republicans and the Democrats in the last election cycle. But now this valuable legal right has been lost, in part because during the general election campaign, Franken and McFadden decided to go to the media and began to treat me as a minor party candidate, although I was a major party candidate, regardless of whether I sought endorsement by others, who I considered extremely immoral and dangerous to society, pushing drugs and homosexuality, lesbianism. My viewpoint was protected against viewpoint discrimination in debates. This was a serious violation of the First Amendment rights of the voters, including me, of the IP itself, and of mine as the Senate nominee. Further, Franken and McFadden impermissibly excluded me because of my party affiliation with the IP. And let me point this out. If Al Franken had been the candidate for the IP for the U.S. Senate, he would have got something like 4 or 5%, because he can't debate the issues, and he relies solely on the incumbency of this socially engineered party, which needs a figurehead, since they really have no coherent message, since they can't discuss the issues, and they can't just be the American people coming together deciding the issues and their positions. So Al Franken looks big because he's with the DFL party, but if he was with the IP, he would be in exactly the same situation that I am. And furthermore, in the Duluth debate, they decided that they just didn't want the IP in. They said a long time ago we decided that because Democrats and Republicans control the Senate, that therefore we are going to just exclude the third party. Well, this was the major party, and the obvious result of their decision was to endanger that 5%. They did this to Hannah Nicollet. In all of the high-level debates, the high-level races involving IP candidates, they excluded us from the debates at will. And so this show of power just sort of told people, hey, the media don't like the third party. The duopoly doesn't like the third party. Now, there's third parties all over this country. And it was clearly stated in the New York Times that Republicans and Democrats all over the country got rid of the nuisance of a third party, a legally declared third party with every right to be in those on the ballot, and they tried to get them to control their influence by keeping them out of debates. So this is something that the United States Supreme Court has to look at, something the United States Senate needs to look at. It's just not me and Al Franken. It is the entire country. They are establishing officially a duopoly, even though it's against the law and the Constitution. But they do it anyway because they get all excited about wanting that big federal budget, that $3 or $4 trillion a year federal budget, which I would reverse the growth of that by transitioning the power and the resources back to all of the 50 states. They don't want to hear things like that, so they had their debates. So to go on then, I was excluded. I'm actually reading from the actual contest that was already submitted and has been answered by the Secretary of State, but not by Al Franken, and will go on before a panel of judges, and then that evidence on these issues will be brought to the United States Senate, and it's also going to the United States Supreme Court, where it actually has already been, but just on a motion for injunction before the election, desperately trying to get in the last debate. So the amazingly frank admission, I would say, of the partisan motives of Al Franken and Mike McFadden and the organizers of the Duluth debate are also in violation of the equal time provisions, which require that if a licensed broadcaster extends the use of facilities by a broadcast debate, quote, I'm quoting now from the law, it must extend the same opportunity to all legally qualified candidates, unquote. This rule, which reflects the First Amendment and its interpretation by the Supreme Court, has not been overturned, and the rule was violated by Al Franken and Mike McFadden. And so now I'm going to get into a little bit of the background The elimination of my viewpoints from the debates renders the election invalid because it violates the First Amendment, defying the U.S. Supreme Court mandate in Buckley versus Vallejo, that conduct of the election must reflect, quote, a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. And that court, and actually I believe that was in Buckley, but it was also specific. This is a statement also from the Anderson case from 1980, another U.S. Supreme Court. So that, but they're citing the New York Times Company versus Sullivan from a 1964 U.S. Supreme Court case. The campaigns and organizers used fringe, etc., to call me names. However, although some in the IP joined to try to discredit my win in the primary, in fact, I had polled 13%, well above the 5% needed for the party to survive in July 2014. Therefore, there's no doubt that I could have, if treated as a major party and included a major party candidate within the scheme of Minnesota's election laws, fixed before the election and included in the debates, I could have made the 5% and kept the party on the ballot. This makes the deleterious impact of the Franken-McFadden actions material, because they resulted in the loss of the IP major party status. In addition, my YouTube videos, like this one, show that my positions on issues important to the voters are better than Franken's, who votes for 97% with Obama, essentially exercising little or no thought or leadership, and McFadden's. And I can win debates. That is why they were afraid to debate me. Me crushing Franken in a serious debate, compared with his bumbling, flustered responses when confronted by McFadden and those in Duluth who favored mining projects he has stalled for years, but which he says he wants to do on the science, he wants to do it, would have devastated such a defeat, just pointing out just his silly position that he still wants to do it after 9 years of opposing it, even though it's going to poison the groundwater. That would have devastated even those 25% who voted for him, because only 25% of the eligible voters finally did choose to vote for him. And that is the basis, that 25% is the basis of the Canvassing Board's November 25th declaration that he won. 25% of the state voted for him, so he won. And supposedly a resounding, great approval, all the rest. And the main impact of excluding the IP from the so-called debates was to drive down turnout, because voters didn't hear any candidate that interested them in the so-called Senate debates put on by My 9 TV, KBJR, WCCO, CBS TV, and NPR radio station, all FCC licensees and public broadcasters whose limited events were accompanied by much fanfare and ballyhoo in the press. Oh, the Senate debate. Well, it wasn't the Senate debate because it didn't include the candidates. It was a show debate for Mike McFadden, who had no experience in politics, to pretend that he had some solutions outside the standard party line to solve the great problems which our country continues to face, and I address in many of my other videos. Not until the third debate did McFadden awaken to what I had been charging since before the primary, that Franken's claims that he had worked across the aisle to break the gridlock and accomplish many legislative achievements were completely hollow and empty. I would have torn a gaping hole in that facade with debate 1 in Duluth, and seriously and materially altered the vote to make it a competitive race. And that was the intent by the contestee, Franken, who is a sharp operator with the FCC and public broadcasting, is to simply make sure that I was not allowed to get anywhere within 10 feet of him on any stage, because he wouldn't look too good. Ground 4. Despite the fact that voter email addresses collected by the Secretary of State are public information, as I mentioned, under Minnesota Statutes Chapter 13, this is the Minnesota Government Data Practices Act, Contestee Mark Ritchie and the DFL denied me the use of these, even though they provided phone numbers for all the registered voters. So I got millions of phone numbers. I mean, that's more personal to me than an email address. And this is something that just has not been addressed by the courts, and it needs to be. Because we could take all the money out of politics right now. If we could all communicate during an election, the nominees could send their message to all the registered voters, who, if they didn't want it, could mark it for spam. But they would be able to talk back to the campaigns. We'd be able to talk across campaigns. We wouldn't need all these 30-second sound bites, and we wouldn't be totally reliant on these rigged political debates to find out who people are and what they think. Because I watch these to find out who they are and what they think too. I mean, everybody needs to watch these, or we don't have a democracy. So if we could go back on email and surpass the debates, surpass the newspapers and the TV stations who are manipulating all the information with their own agendas, people like MSNBC, CNN, we would be able to find out the information we needed to make our selections. So here's just a short discussion of the legal foundation for this contest. So I know that the Secretary of State's Attorney General representing him has complained. There's arguments here. Yes, it's not just a bald statement, a formal statement of violations. I have to provide enough detail, and I would say plausible legal theories, so that any court and the United States Senate could understand what is the substance so that we can document the evidence of this. I'd like to call Al Franken, I'd like to call Mike McFadden and Mark Ritchie, and perhaps others as witnesses in this short, quick trial, so that the results can be sent to the United States Senate to show them the irregularities in this election and the serious material and deliberate actions of Al Franken and his campaign, including his party, who he's associated himself with. All right, so according to the U.S. Constitution, let's start with that. Article 1, Section 4, Clause 1. The election laws are to be prescribed in advance of elections by the Minnesota legislature. That is to say, they are fixed, predetermined, and established. Thus, they are not subject to the caprice of rich, powerful, and amusing incumbents like Senator Al Franken, or of rich businessmen like Mike McFadden as the nominee of the Republicans, just because the election itself is already underway, leaving these political demagogues to decide they're going to exclude the third party from all public appearances and take away their major party status when, predictably, either they do get the votes that might have gone to the third party, these people who are on TV take those votes, or the turnout diminishes, as it did this year, the lowest in 5 election cycles. Minnesota used to be, supposedly, before Al Franken got here, supposedly we were the greatest voters in the country. We turned out for every elections. Wow, exciting. And this time, they didn't respond to this program that was put before them. Yet this is what happened. And this occurrence violates our nation's fundamental expectations. I'm going to quote Justice Samuel Miller, author of the Yarborough case from 1884, who said, if this government is anything more than a mere, he's talking about the federal government, than a mere aggregation of delegated agents of other states and governments, each of which is superior to the general government, the federal government, it must have the power to protect the elections on which its existence depends from violence and corruption. If it has not this power, it is left helpless before the two great natural and historical enemies of all republics, open violence and insidious corruption. We're starting to see quite a bit of that as a threat. There was plenty of violence that was made the principal subject matter of this election by the Obama administration, bringing up things like the police and riots and insurrection, burning down buildings, and that was nicely played by the administration. As serious as that issue is, it should not have been used as an election prop. And Al Franken had to get right into this one too and attack the police and say that, well, we need justice, we need an indictment. So there was both violence and corruption that are the enemies of democracy in Minnesota. Miller described the Wild West approach to the elections, including requiring a steady elections require the steady rule of law to protect this fundamental institution of our democracy. Once the election starts, this is not the time for judges, no matter how highly they esteem themselves, to suddenly limit their own jurisdiction. According to Minnesota Statutes 209 contests and Minnesota Statutes 204B.44 errors and omissions, the manner or scheme of elections for U.S. Senate as fixed by the Minnesota legislature includes two forms of judicial involvement, and this is not up to the whim of any particular constellation of the Minnesota Supreme Court. The judicial duty includes contests, such as this, filed within 7 days of the certification of a declared winner, which is a statute of limitations and is not governed by laches or other equitable remedies, as the Supreme Court erroneously declared in 2012. In other words, 7 days is 7 days. You can't say, well, you should have acted faster, you should have acted before the election because Betty McCollum or Al Franken, they're entitled because they're the incumbent. And so you have to act as soon as you had any idea about anything, otherwise they're prejudiced. Even though they haven't been elected, but they're still going to be prejudiced. So this is before their election. So these things have to be fixed, and they can't be decided on the basis of laches. But yet, that's where the Minnesota Supreme Court has erroneously and benightedly gone with our elections. And they've also established petitions. I'm talking about the Minnesota legislature, which are filed during the course of elections. And they rely on the judiciary, these Minnesota Supreme Court people, to enforce duties during the election so it will not be marred by corruption as partisan events unfold. When a party does something which violates the rules, keeps information from the voters, just because they think it creates an advantage or it casts the smaller party candidate in a lesser light as if they're weak or somehow less qualified, that is corruption. Al Franken is corrupt, the Minnesota Supreme Court acted corruptly, and it's obvious that Mike McFadden would fit right in with corruption. This is getting a little longish, and so I am going to continue this in part 3. Thanks for watching. My name is Steve Carlson. I want to fight for free and fair elections and democracy here in Minnesota and across the country, and looking at the 2016 election. I want to make sure that the Independence Party retains its major party status, and that's why I'm going to the U.S. Senate and to the United States Supreme Court. And I am calling out Al Franken on his corruption in this contest.